Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing bank accounts in the context of the U.S. immigration process, specifically spousal visas. So we're talking about CR-1, IR-1, and K-3 visas here in Thailand. So the thing to, first of all, take away from this video is we're talking about Thai bank accounts. We specifically mostly do cases out of Thailand, so I kind of take a Thailand slant on these topics. That said, this analysis may be useful for folks in other jurisdictions talking about offshore bank accounts generally. And the topic at hand is this. Oftentimes when folks need to go ahead and sponsor their immigrant spouse to the United States financially, they oftentimes will be asked to provide proof, documentation that they have financial resources. Sometimes people have offshore bank accounts. For folks, especially retirees here in Thailand, this is a frequent thing. And many of my, especially retiree clients, but also folks that just live here, expats, younger guys living and working out here, they'll ask me, hey, can I use my Thai bank account as proof, as financial proof, as part of the visa process? And my answer to that is effectively no, because basically, U.S. immigration wants to see that money in an American account. And the question posed is why? Well, one, they can trust it better, the veracity of it. I think that's one concern, is look, an offshore institution, you know, the U.S. doesn't have jurisdiction over them. They can't fully ascertain the truth of whatever assertion regarding finances is made. That aside, I don't think that's so much the issue. I think it more has to do with attachment down the road of people that act as sponsors for immigrant visa status to the United States. And basically, the U.S. government wants to be sure that you don't bring an immigrant spouse into the U.S. and then basically that spouse goes on effectively welfare, means-tested benefits. And with regard to finances, they want to make sure that if, in fact, that was to happen and they needed to go ahead and seek recompense from the sponsor, that the sponsor actually has not only money and financial resources, but that those resources are within the grasp of the government. So again, within the jurisdiction of the United States. So with regard to Thai bank accounts in the U.S. immigration process, specifically the spousal immigration process, immigrants, IR-1, CR-1, as well as the K-3 non-immigrant visa, I think in those circumstances, what you're looking at, what you're dealing with in terms of visas and sponsorship, they're going to want to see documentation pertaining to American banking or financial institutions, not offshore banks and financial institutions.